At first glance, a document like this looks, well, honestly kind of boring. It's just a legal order. But if you know how to read between the lines, it tells a really dramatic story. So today, let's break this thing down, piece by piece, and uncover the pretty wild story hidden in all that legalese.
And this one line, this is the whole mystery right here. I mean, just think about it for a second. You're the one who filed the lawsuit, right? You show up for your big day in court, and then, right in the middle of presenting your own case, you just quit. You walk away. Why on earth would anyone do that? Who is this he, and what could have possibly happened?
All right, to get to the bottom of this, all we have to go on is the official court order from that day. This document is basically our roadmap. So let's start at the very beginning and set the scene. Okay, so every legal drama has its key players, right? Here are ours. On one side, we have the petitioner, a Mr. Roland E. Littell. He's the guy bringing the complaint. And on the other side, we have the respondent, Vista, Montana Estates. They're the ones who have to answer that complaint.
So, and this is the crucial part, Mr. Littell is the one driving this whole thing. He's the one who filed the paperwork, probably paid some fees, and got this entire legal action started. He wanted this hearing to happen. Now, keep that in mind because it's going to be really important in a minute.
Now, don't picture some big, dramatic courtroom scene from a movie. This is what's called an administrative hearing. It's still a very formal legal process, but it's happening at the Office of Administrative Hearings in Phoenix, and it's presided over by an administrative law judge.
And check out how fast this all happened. The hearing starts on April 30th. Just 6 days later, on May 6th, it's completely over. The judge issues the final order. That is an incredibly quick turnaround for any kind of legal case, and that's our first big clue that something pretty unusual went down. So what happened? Well, the wild thing is, the hearing started out totally normal, just following all the standard procedures, but then it hit a massive roadblock. So the day kicks off, the hearing is called to order, and Mr. Littell, our petitioner, gets up and starts his presentation. He's laying out his side of the story, he's showing his documents as evidence. Everything seems to be going exactly according to plan.
And boom, here's the conflict. A major disagreement explodes between Mr. Littell and the judge. First, over the scope of the hearing, meaning they couldn't even agree on what topics they were allowed to discuss that day. And second, over the admission of evidence. The judge was making decisions about what testimony or documents could be included, and Mr. Littell clearly, strongly disagreed with those calls.
So faced with a judge who he felt was boxing him in, limiting his case, and throwing out his evidence, Mr. Littell made a pretty shocking decision. He just declared he was done. He was pulling the plug on the very hearing that he himself had started.
So what happens when a hearing just goes completely off the rails like this? Well, the judge can't just bang a gavel and say case closed. There's a formal process you have to follow, especially when the person walking out has so much on the line.
The judge, a man named Louis D. Kowal, was very careful here. He didn't just let Mr. Littell storm out. First, he gave him a moment to think it over, to reflect. Then, he spelled out the consequences in no uncertain terms. If you do this, you're going to lose your filing fee. It's gone. Only after that did he ask for a final confirmed answer.
And the answer came back, yep. Despite the warning, despite the chance to take a breath and reconsider, Mr. Littell stood his ground. He confirmed it. He was withdrawing. For him, you have to assume the principle of the matter was worth more than the money. So with the petitioner's decision now locked in, the only thing left was for the judge to make it all official. And that brings us to the actual document we're looking at, the final order that puts a legal seal on everything that happened that day.
The order really does two main things. First, it dismisses the petition. That basically means Mr. Littell's case at this specific court is officially over. It's been thrown out. Second, it vacates the hearing, which is legal speak for wiping it off the court's official calendar or docket as if it's not a pending issue anymore.
And all of this was signed, sealed, and delivered on this date, May 6, 2008. The judge put his signature on the order, and that specific chapter of this whole dispute was formally closed.
But was that really the end of the story? Not even close. If you read these documents really carefully, they often leave little breadcrumbs about what's coming next, and this one is no different. This wasn't an act of surrender. And there it is. The final sentence reveals Mr. Littell's master plan. He wasn't giving up the fight. He was just moving it to a different battlefield.
He actually told the judge he was going to sue Vista Montana Estates in civil court. This whole withdrawal, it was a strategic retreat, not a defeat.
So it just goes to show you, a legal order can look like a final ending, the last word on the subject. But as we just saw, sometimes it's just one door slamming shut right before another one opens. It's a snapshot of a single, dramatic moment in a much longer fight. And it really makes you wonder, when one case gets dismissed, is the real story just beginning?